All right. That made everybody jump, didn't it? Where are you going, Mr. Towns? All right, you promise? That reminds me, one night on a traffic stop, I stopped a car and the driver had peeled off a blue ribbon beer bottle label and had it stuck to his forehead. And I said, "What in the heck is that?" He said, "I'm on the patch, man." It is Tuesday, February 27th. This is the House Criminal Justice Full Committee. If you're on the wrong room, you can find your way out now. Madam Clerk, please take the roll.
Representatives Carringer, Davis, Doggett, Farmer, Fritz, Glenn, Hardaway, Howell, Johnson, Lamberth, Moody, Russell, Towns, Vice Chairman Gillespie, Chairman Halsey. Mr. Chairman, you have a quorum.
Thank you very much. Are there any personal orders today? All right, seeing none, we're going to jump into the calendar. Item number 1, HB 2728, has been rolled for 1 week. That puts us to number 2. Leader.
Mr. Chairman, I have a motion, if I may.
I'm sorry?
I have a quick motion, if I may.
Indeed.
Thank you, Mr. Chairman. I'd make a motion, roll item number 3, 2 weeks after consulting with the sponsor and legal for a technical clarification.
All right.
2 weeks.
Any objection? We're going to roll House Bill 1949, which is number 3 on the calendar, for 2 weeks.
Thank you, Mr. Chairman.
Chairman.
Mr. Chairman, I'm out of order, and I apologize for this, but with us today is my good friend and our district attorney general for Giles and Lawrence and some other counties, but he's here with us today, Mr. Brent Cooper.
Welcome, Mr. Cooper.
He
Glad
heard
you're
that
here.
you were going to take him out to dinner tonight, so I just...
Okay, all right. That brings us to item 2, House Bill 0430, by Chairman White. Oh, Chairman Farmer, you're carrying the bill. We got a motion and a second. You are recognized, sir.
Yeah, thank you, Mr. Chair. And looks like I have, and I don't know if this has traveled with it, looks like we need, what is amendment 013331? Is that what we're on?
Second.
All right. We have a motion and a second on amendment 013331. Okay, we are voting to attach amendment 013331 to this bill. All those in favor say aye. All opposed, no. The amendment's now on the bill. And that's the technical correction.
Motion amendment code 14444.
All right, I'm catching up.
Question amendment 14444.
Question's been called on amendment 014444. We're going to attach that. Well, that's just a technical correction. All those in favor say aye. All opposed, no. That amendment's on the bill.
All right, thank you, Mr. Chair.
Is there a motion to roll these two amendments together? Is there a sec? I heard a second. All right, we're going to roll these two together. If you vote aye, all those in favor say aye. All opposed, no. Ayes have it. They are now wed.
And
Okay, Chair.
And thank you, Mr. Chair, and I'm sorry for the confusion. Chairman White, I believe, is in Education Committee now presenting a bill. So I have the pleasure of running Speaker Sexton's House Bill 430. Members, you all may remember, well, some of y'all have heard this in the subcommittee, which I'm reluctantly, I'm unable to sit on, but I've heard this in subcommittee. It's similar to, but not the same as the bill that we passed in special session here just a few months ago. What this does is, well, let me start off with saying this. The youth in our state and all across the country has changed dramatically since the last time this area of the code has been amended. I had the luxury and had the learning experience of serving on the Juvenile Justice Ad Hoc Committee a couple of summers ago, and I was able to go around to every one of our youth development facilities in the state and get to know and get to see what was going on with regards to our youth there. And I can speak firsthand to the fact that there is some good. There's a lot of good in states and other places that have a blended sentencing model, because the fact is some of our youth aren't ready to move on at 19. So what this bill would do would allow for us, the state, the Department of Children's Services, in correlation with the Department of Corrections, to hold, whether that be incarcerated in custody hold, or that would be under some sort of supervised probation, until these youth are able to move and transition into society as productive citizens. And, unfortunately, some of these youth, had never had the opportunity to know what it was like to have rules and boundaries. Most of these youth never had the opportunity to have a family, whether it be a mother or father. And in most, I'd say, of these youth, all they know and all they were taught, unfortunately, is how to break the law. And that's how they survive. And we're taught to survive. And that's unfortunate. So I think as a state, we have a duty to step in and provide the services to these youth for as long as possible. And what this blended sentencing model would do, it would allow us to provide those services for these youth past the age of 19, up until they're 24 years old. So I think that this would also help us give them the services they need well beyond that 19th birthday. So this isn't a bill designed to just lock away the youth after 19. This bill is designed to help where they've never had the opportunity to be helped before. So I want to kind of hop into the main points of the bill now, members and audience. There's certain A and B felonies that right now that youth 14 and up could be transferred to adult court. There's two paths right now. Either A, depending on the crime and depending on how it was committed, the youth could be on this list of crimes. That's first-degree murder, second-degree murder, rape, aggravated rape, rape of a child, aggravated rape of a child, robbery, aggravated robbery, especially aggravated robbery, aggravated burglary, especially aggravated burglary, kidnapping, aggravated kidnapping, especially aggravated kidnapping, commission of an act of terrorism, carjacking, aggravated child abuse or aggravated child neglect, endangerment, criminal attempt to commit any of the offenses, any of those offenses there. Those are all A and B felonies right now. So the law says that any youth that commits one of these crimes can be either A, if they've been adjudicated to have committed one of these acts, either A, they can be held in the department until they're 19 years old, or B, the law says that they could be transferred to adult court, and that's 14 or up, and that's what the law says right now. So what this bill attempts to do is allow for another mechanism, another tool in the judge's pocket to give these youth the help they need beyond 19. So now, if it's a first-time offense of any of these offenses here, if this is the first time this has happened, and they're found to be a substantial youth offender, a substantial youth offender, a serious youth offender, then the judge, or the district attorney would make the recommendation to the judge whether or not that youth have the be able to participate in the blended sentencing model. So then that judge would have three options. One, that youth could be transferred. Two, that judge could continue to hold the youth until 19, or they could enter into that blended sentencing model, which will allow for that judge to say, look, we're going to hold you until you're 19, but then once you turn 19 years old, we're going to have another hearing. We're going to see how you're doing. And if you're doing well, you know what? We can let you move on. If we think you need a little more help and you've met certain criteria, but maybe not, or you haven't met certain criteria, then I'm going to hold you a little longer. And it's up to that judge's discretion whether that youth is going to be held in custody or they're going to be on supervised release while they're getting the services that they need beyond 19. I think that's a very important part of this bill. We are providing services to these youth, or they're going to have access to these services beyond the age of 19, which is not possible right now. Right now, the youth, they're staying in the state's custody until 19, whether that be in some sort of hardware secure facility, or whether that be under some form of probation, that youth is being monitored by the state in that way, and then they're just cut loose at 19. So, so that's that part of the bill. I think that's a big, important part of it. This majority of the bill is how it works, how that works. And then once the youth turns 19, the judge, let's talk a little bit about this hearing, what's going to happen. There's going to be a hearing to determine how this youth's doing. So once the youth turns 19, the judge is going to look and say, hey, has the youth committed another delinquent act? Has the youth engaged in conduct that creates a substantial safety risk? Have they failed to meet the conditions of supervision during the determinate disposition prior to the hearing? Have they failed to attend school? How are they doing? Are they passing? Are their grades? How are their grades? Have they maintained employment, as they were ordered to do so? If they meet 3 of those criteria there, if they've done 3 out of the 5, then that judge can allow them to move on. Hey, you know what? You're doing what you need to do. We don't think you pose a substantial risk of harm to society anymore. Move on. Let's wish you the very, very best. Good work, good job. Let's let them move on. But they haven't. They're just not ready yet. So then that judge can make that determination at his or her discretion whether or not to hold that youth in custody for another period of time up until they're 24, or maybe they allow them to be on some sort of supervised release while they're getting the services they need. If they commit a second offense of those crimes, now we're talking, now I just explained that was the first offense. If they commit this offense again, then the district attorney would not just be able to make the recommendation to go down the blended sentencing route. The judge would have to send that youth. If he didn't transfer to youth, he or she didn't transfer to youth, or didn't, well, bottom line is, it's either transfer or blended sentencing route at that point in time. So if they're a repeat offender on one of these crimes, then that's on the second adjudication to have committed one of these crimes, then you have 2 options are: 1, either they're transferred if it meets that standard, or number 2, they go down the blended sentencing route. And then everything else I just explained applies. So you got first time a recommendation comes from the district attorney's office, hey, he or she could recommend the blended sentencing route, and then that judge has the discretion to implement it, okay? The second time, the judge has less discretion. The judge can transfer, or it goes down the blended sentencing route, and everything I just explained applies, as I just said. The only times that a youth is sent is going to be transferred automatically is if that youth has committed first or second degree murder, or has committed the attempt of first or second degree murder, and that youth is 16 or older, then that youth will automatically be transferred to adult court. That's the only hard and dry, cut and fast exception there are. That's the only way to automatic transfer in this bill, is if the youth is 16 and up and they've committed either first or second degree murder or attempt of first or second degree murder, and then they'll be transferred to adult court without any sort of discretionary component. Otherwise, this bill is full of discretion and transparency, and the goal is, and the policy behind this legislation is to get our youth as much help as possible and give the judges, the elected judges in our state, the ability to help these kids continue and stay on the path that to be productive and successful citizens here in the state of Tennessee. So, and elsewhere. So with that, Mr. Chair, members,
Okay, thank you. I think we have 3 folks here to testify on this bill. Eric Alexander, Zoe Jamil, and Melanie Bean. Are these 3 folks here? Please come forward. And if you will, make sure that the red light's on your microphone. And you each have 3 minutes. And will you please introduce yourself for the record?
Okay, Hi, my name is Jasmine Miller. I believe I submitted a testimony form by paper to your assistant Rose yesterday. Do you want to check that I'm good to speak?
Yes, I have you. Go
Okay,
right
great.
ahead.
All right, thank you. My name is Jasmine Miller. I'm a staff attorney with Youth Law Center.
Hi, I'm Zoe Jamale, and I'm the Policy Coordinator for Disability Rights Tennessee.
My name is Melanie Bean. I'm a practicing attorney in Middle Tennessee, and I currently serve as Vice President of the Tennessee Association of Criminal Defense Lawyers.
Eric is here, but I believe he just stepped out for a moment. I just texted him to come back into the room. All right, well, I guess I can kick us off. The newly amended version of HB 430 includes a blended sentencing component and a transfer component. I'm going to focus on blended sentencing, but please feel free to ask questions about transfer if you have them. As Representative Farmer noted, the concept of blended sentencing is to allow a juvenile court to impose a juvenile disposition and an adult sentence at the same time, with some mechanism through which the youth can demonstrate that they are rehabilitated and have that adult sentence lifted. However, blended sentencing schemes are complicated and require significant resources to implement appropriately and constitutionally. Without careful attention to every word in the scheme, unintended consequences do abound. And I'm going to highlight a few by going through an example of how this scheme would apply to an individual young person. Alana is a 14-year-old whose older boyfriend recruited her to serve as a lookout during a robbery. She is charged with aggravated robbery, and the DA asked to classify her as a serious youthful offender, even though it is her first-time offense. The judge has no choice but to classify her as a serious youthful offender, even though it is her first-time offense. She's committed to DCS until 19 and given a 3-year adult prison sentence. Under this bill, two things could happen at this point. One, the judge could stay the adult sentence and have a hearing to reevaluate whether to impose the sentence when Alana is 19. Or the judge could not stay the sentence. If the judge does not stay the sentence, Alana will automatically serve 5 years in DCS custody and 3 years in adult prison. She will have no ability to ask the judge to reconsider. She will go to prison without having a jury trial. If the judge does stay the sentence, Alana will go before the judge within 4 months of her 19th birthday. Now, when Alana first goes into DCS custody as a 14-year-old, she's still struggling with her relationship with her older boyfriend. She sneaks out of her group home placement a couple of times to meet with him. He gives her some marijuana. She offers it to a friend. She gets in trouble, but slowly she's able to build a strong relationship with her therapist and begins to understand that her boyfriend is exploiting her, breaks it off, and over time she heals, graduates high school, enrolls in college. Now, under this law, when she goes in front of the judge has to send her to adult prison for 3 years because she failed 3 of the conditions in the hearing, right? When she was 14 and she snuck out to meet her boyfriend and she possessed the marijuana and she offered it to a friend, she violated her terms of supervision, she committed a delinquent act, and she engaged in conduct that posed a safety risk to others. There's no way for the judge to not impose that sentence. Now, you might think, well, can't the judge order probation? Under TCA 4035-303, which governs probation eligibility in the adult system, aggravated robbery is not eligible for probation. So there's no mechanism that the juvenile court could use to modify the sentence to include probation rather than incarceration. So Alana has to go to prison, no matter how much she's done to atone for her crime. This bill has unintended consequences. It has drafting issues. It has constitutional issues. I've reviewed blended sentencing in 19 other states that have blended sentencing. This bill has major constitutional flaws that are not present in those other states, in particular, the lack of a jury trial for youth who are facing prison sentences. I ask that y'all take that into consideration as this bill moves forward. Thank you.
Next.
Thank you so much for the opportunity to speak. I'm going to talk a little bit about transfer and then a little bit about the factors for the adult portion of the sentence. So when the Joint Ad Hoc Committee adjourned, Chair Lady Littleton said, providing alternative avenues that address behavioral issues but allow children to avoid the criminal justice system is in the best interest of everyone. And we agree. I'll note that this bill will take significant resources to implement, where the state could instead be investing in evidence-based services that are proven to help with rehabilitation and avoid reoffending. To be clear, there is nothing in this bill about the provision of services, and none of the costs are associated with such. The fiscal note on the bill is $4 million, but it could be more given that it is based on a placement cost of $400 per youth per day, but a placement at Wilder Youth Development Center is $1,600 per youth per day. It would have to be more to include the services discussed during the bill's presentation. The importance of the juvenile justice system, especially when it comes to youth with disabilities, cannot be overstated. It was created to improve societal outcomes by protecting and rehabilitating youth who have been adjudicated delinquent. The interventions and primary rehabilitative objectives of juvenile justice are not found in the adult system, and there are no guarantees in the adult system that youth will receive age-appropriate or special education, mental health or substance abuse treatment, or will be taught life skills. Adult corrections facilities are dangerous for youth. Youth held in adult jails are at much higher risk of harm, sexual attacks, rape, suicide, than if they were to be placed in a juvenile facility. The rate of violent victimization against persons with disabilities is at least double the rate for those without. Youth sent to the adult system are approximately 30% more likely to reoffend or to be rearrested after their initial offense than if they were prosecuted in juvenile court. Okay, I'm going to talk a little bit about the blended sentencing part of this bill. And I'd like to focus on the factors that a court must rely on in determining whether it is required to impose the adult portion of the blended sentence. I'll reiterate what my colleague said, that the court can only consider these 5 factors and no other extenuating circumstances such as disability or other life circumstances that may result in failure to meet 3 of the factors at no fault of the youth. It's also important to note that where the young person is placed during the juvenile portion of the sentence will likely impact the youth's ability to meet the requirements for avoiding the adult sentence. So I'll go through each factor. First, committed another delinquent act. This does not require that a young person be adjudicated for the delinquent act. Do they have to be caught in the act or arrested for it? Is it just an allegation of a delinquent act sufficient? The second factor, engaged in other conduct that creates a substantial safety risk. What is a substantial safety risk? Is that a risk to self or others? Is that speeding? It doesn't have to be a crime. Failed to meet the conditions of supervision during the determinate disposition prior to the hearing. This could be something as small as missing curfew. If a young person committed another delinquent offense, it would likely qualify as a failure under this subsection as well. For the education portion, barriers to accessing education, especially special education, have to be considered when we're talking about this factor. We see youth all the time in facilities who are experiencing barriers to education. And that's it for me.
Thank you. Next.
Find my comments to specifically discuss subsections G4, G5, and G6, which are being amended to TCA 371131. And for reference, those would be found beginning on page 3 of the bill. What I want to note specifically, and I noted as Representative Farmer was presenting the bill, was that Representative Farmer identified that the intent of the bill would be at age 19 to have a hearing to see where this serious youth offender is in their process. However, under G4, an additional disposition shall be imposed by the court, and that is under subsection G4. The requirement of a hearing is not triggered until subsection G5 and subsection G6. And so a hearing at age 19 is only triggered if the court initially issues a stay under subsection G5. So a hearing at age 19 is not guaranteed to this serious youthful offender. In fact, under subsection G4, it appears to be unilateral. Not for sure that the drafting was intended this way, but automatically under subsection G4, an additional disposition, basically a resentencing of this defendant or this juvenile delinquent, is automatically added of 3 to 4 years at that point. So unless there is a stay that's been issued that triggers G5 or triggers G6, the additional sentencing of 3 years or 4 years is automatically added. Again, I'm not for sure that that's what was intended, but that is the way the bill is drafted. So let's think about some of the problems that would identify there. Here, we are now resentencing a defendant as an adult to an additional 3 to 4 years. That is happening without a jury trial. And in the United States of America, in the state of Tennessee, we do not incarcerate our adults without a jury trial. This bill does not address the constitutional right to a jury trial at any point. Let's say the representatives or anyone who's here says, okay, well, how can we fix that? The problem is by the time you get to subsections G4, G5, and G6, the subject has the defendant as the delinquent. Sorry, I use the word defendant a lot because I practice in adult court quite a bit. The addition of a jury trial at this point, there is no jury trial to have. The delinquent has already been adjudicated on the underlying facts. So even if there was an attempt to amend the bill or to somehow add a jury trial in at some point prior to the adult sentence being entered, there's nothing to try. The underlying facts have already been decided. So we have a serious flaw. And let me say this, I'm not necessarily, even though I'm here as a representative of the Tennessee Association of Criminal Defense Lawyers, I'm not against the idea of blended sentencing. I certainly can identify, reasons why the sponsor and other individuals who support this bill, why they would find it to be important to address and put some intervention in for our youth. But the fact is that the way this statute is set up, we have some serious constitutional flaws, and the mechanisms and procedures are just simply not in place to give notice, due process. Who can request a hearing? How can we request that hearing? Who's in charge of it? Can we even appeal it? None of those mechanisms are in place, and I think with some additional time, we could add some policies to the bill in order to sufficiently address some of these issues. And with that, I believe my time is up.
Ms. Bean, yes, it is, and I'm sure that you can continue because there will be questions, I'm sure.
Thank you.
Representative Johnson.
Thank you, Mr. Chairman. Yeah, I guess, so we're talking about no jury trial, but a sentence of 3 to 4 years. I really want to understand how this works and what we're doing here.
So again, under subsection G4, the court shall impose an additional disposition. That occurs with no hearing. It can be automatic based upon how the statute is written. In addition to that, there's no scheme or procedure in place about how the defendant is even notified about that additional 3 to 4 years. Again, the hearing is not automatic. And at this point, there has been no jury trial for that defendant, nor does this bill or statutory scheme set up a jury trial at any point. So that constitutional flaw is just built within this policy and really would have to be addressed in order to create a policy that really could be implemented in order to create intervention for youth. I would also point out to move further into that argument, Representative Johnson, that under subsection G5, when a court issues a stay, there's no mechanisms or procedures that are identified within the statute about who requests that hearing. When is that hearing held? Is the defendant entitled to counsel at that hearing? It's just that if the judge issues a stay, you have to have a hearing within 4 months of that 19th birthday. And if and there's, again, it's not a jury trial at this point either. It's just the judge having a hearing to determine whether those factors that are set out under subsection G5, whether that would then permit an order having the additional sentence. So at that point, there is still no jury trial, but then these constitutional due process mechanisms just really aren't built into the statute. So what that would mean is that we would really, at the same time, we really need to be amending the juvenile rules of procedure so that we can establish some of these rules and mechanisms so that we can really have a policy and a bill that can be implemented at the moment that it's passed. Right now, we really don't have those mechanisms and procedures really built into the bill as it is drafted. And then the same issue with subsection G6. And subsection G6 is only applicable after the court has had this initial hearing, only if a judge, he or she, has issued a stay. And so those, and again, none of those mechanisms under G5 or G6 really address how the hearing is requested, what notice is given to the defendant, and whether they're entitled to counsel. And when we're talking about the entitlement to counsel, because it is a resentencing, I think it's incumbent that they would have to have counsel at that point. So then it begs questions such as, well, is this the same attorney who represented them the first time? Is this a new appointment? Is the attorney on the case for 6 to 7 years or longer? Does that attorney wait to issue their AOC appointment? Is it an adult attorney? Is it someone who primarily practices in juvenile court? So there's a lot of fundamental internal procedures and mechanisms, again, that just really have to be built into this bill. One additional thing that I would like to add to that is all of these offenses that would cause someone to be a serious youthful offender would, when they are adjudicated on that underlying offense, they are offenses that require them to be committed to the custody of the Department of Children's Services. And so a misnomer in some respects is while a juvenile court has the authority to continue to have jurisdiction of that defendant and can check upon that defendant, at the moment that child is committed to the custody of the Department of Children's Services, the Department of Children's Services is the sole determining entity of where that child is held, not the judge. The Department of Children's Services. And I think that there's a lot of concerns that can come with that. A second point that I would make there is if within this bill and this blended sentencing model, we're able to fix the jury trial issue, we're able to fix the resentencing, amend the rules and procedures and statutes, we would also at the same time, we're talking about in portions of this bill, the child remains in the custody of the Department of Children's Services until age 19. They're in the custody of the Department of Children's Services. At age 19, if a 3 to 4 year adult sentence is added on at that point, they're in the custody of the Department of Correction. So we really have to build in mechanisms and procedures to transfer that custody. And we already know that under this bill, when they are transferred to TDOC, that they have to still be housed sight and sound from the adults. There's still some additional procedures and mechanisms that I do believe the sponsors tried to put in place, but the underlying fundamentals just really aren't built in and aren't there yet. And so I think that those are some additional things that this committee needs to think about before this bill is actually passed out and we're handing it out to the juvenile court judges and it takes effect in July 1 of 2024 or whatever date is that is selected. And we don't have any of these things in place. Again, this can be a great policy and intervention for the state, but I think that there are some serious flaws just in these 3 subsections that have to be identified and fixed. And again, to point out one of the other comments that was made by the other speaker, I fully believe that Representative Farmer and some of the other sponsors perhaps maybe hope or intend that that's not an automatic incarceration at age 19 for 3 to 4 years. But all of the offenses they're being resentenced for as an adult at age 19 without a jury trial are not offenses that are subject to probation. So again, if probation is supposed to be considered at that point, that is not something that I believe currently as drafted is within the bill. Are there any other questions that I can answer for the committee?
Representative.
Thank you. I appreciate that explanation very much. I also had a question about, can you explain to me how this might affect, impact someone who's a victim of human trafficking?
So I think sorry, make sure I'm on. So I think the human trafficking element is present both in the blended sentencing and in the transfer aspect. In just, when we're thinking about whether or not to subject a young person to a blended sentence, I think, the example that I gave of that young woman whose boyfriend, was perhaps inducing her to commit crimes, there's very limited ability, right, for the juvenile court judge at that point with a 14-year-old to say, hey, I think maybe you should stay in the juvenile justice system and receive, those specific services because I'm concerned about that. But I think where I'm most concerned about the impacts on victims of human trafficking is actually the mandatory transfer component, which we have not yet addressed. So a couple of things that are important to remember. First-degree murder in Tennessee does include felony murder, right? So that includes the killing of someone during the commission of certain offenses, including robbery, burglary, et cetera, whether or not the death was intended, okay? And we sometimes, often see accomplices charged with first-degree murder. And in the situation where, for instance, you are being exploited by a trafficker who is inducing you to potentially participate in crimes, and if you would be mandatorily sent to adult court, and then if you were convicted of first-degree murder, the sentence is life with parole. There's no ability for the court to give you something else, even if they think that maybe, there are some mitigating circumstances. And so, that's really concerning on the first degree murder aspect. On the second degree murder aspect, it's really important to remember that in Tennessee, second degree murder includes, facilitating the death, an overdose death, through distribution of a Schedule I or Schedule II controlled substance. And there's an additional sentencing enhancement there when the person who overdosed was a minor. And we know that in instances of human trafficking, it is very, very common for, the traffickers to control, young people through giving them drugs, right, and making them addicted to drugs. So in an instance where you've got, a young person who is, involved with this trafficker, giving drugs to other young people who might also be being trafficked, one of them ODs, that young person is subject to a charge for second degree murder. Under this statute, they would have to be transferred, and then because of the sentencing enhancement, they are required to serve 25 years, 100%. There's no ability to do anything else because we have truth in sentencing. Second degree murder is 100% crime. And so, that I think that starts to be concerning for folks in terms of whether or not that really is sort of the best situation in terms of a, miscarriage of justice, that sort of thing. And I'll just note that in our current transfer statute, we do have a very specific portion in there where you can consider whether or not someone has been a victim of human trafficking. And I think that the legislature, added that actually fairly recently and very wisely to make sure that in these situations where a person, perhaps committed an act of violence in order to, escape a really dangerous situation, that the juvenile court is allowed to consider that rather than sort of doing this mandatory transfer piece. So I think those are my main concerns. I would also add on the services component. So something that Melanie brought up was the housing component once young people are transferred to, are sentenced to the adult portion of like the serious youthful offender bit. And so there's some language in that section currently that says that the young people who are transferred will have to be, housed separately from general population, which I think, generally makes sense from a perspective of we want to keep, young people safe. But it starts to raise some issues around those people's access to programming, right? Because it's not like we're going to have thousands of serious youthful offenders, especially young women, because young women tend to offend at lower rates than men. And so we're maybe talking about a group of 5. TDOC is going to have to find a unit for them, and then TDOC is going to have to figure out how to make sure that those people have the same access to services such as, right, therapies for, or counseling for folks who are survivors of domestic violence, drug counseling, et cetera. And that logistically just starts to become very difficult when we're dealing with a very small population that is not allowed to mingle with other folks in a facility.
Thank you. I appreciate you being thorough.
Representative Glenn.
Thank you, Mr. Chairman, and thank you all for being here. I had a few simple questions. So you said there's no jury trial for offenders, is that correct? Based on certain parts of the bill?
There is no jury trial. I'm sorry, there's no jury trial built into any amendment to 37-131. There is some reference in another amendment to a different statute that the juvenile court has the same powers as the trial court, but that's not included in any amendment to TCA 37-131, which is the statute that's being amended to specifically include subsections G.
Go ahead.
Okay, thank you, Mr. Chairman. And also, you said there's no eligibility for probation. Is that correct? Did you mention there's no eligibility for probation?
I think both of us have brought that up, yes. Unless there were to be a change to the statute to allow these young folks to receive adult probation. Currently, the adult court is not allowed to give probation on offenses such as aggravated robbery and the others that are in the statute. So if the intent here is for young folks to potentially be receiving a couple of years of probation supervision rather than incarceration, that is not currently possible under the way this bill is drafted.
Okay.
Even, and if I may add, even if that is what is intended, again, I think that it would need to be more clarified and more spelled out within this bill and within the blended sentencing in order to ensure that that is what can occur.
Last question.
Yes, sir.
So based on all that I've heard and all that you've said about this bill, is it possible that a juvenile who is in DCS custody, who may be under some kind of limited custody where they're able to go to work or able to, move around, could something as simple as running a stop sign cause them to go into the blended sentence piece? Something as simple
Yeah.
as running a stop sign?
Potentially. I mean, so there are the 5 factors. And so I think something that Zoe, who had to actually leave to go testify in Senate, she wasn't just running away from y'all. She, brought up that there are some issues around the way that these 5 factors are drafted, and then the concern about sort of doing this automatic fail, right? I think actually the prior version of this bill had similar factors and also included a really positive factor on being able to evaluate people's contributions to the community, and it was written so that there was no auto fail. It was just that the judge needed to consider the 5 or 6 factors, and they could use that to make a determination about whether or not the young person was being rehabilitated, which allows, right, for more discretion around things like, okay, is a stop sign, is that a safety risk? Is that not? Is that a delinquent offense? Is that not? And a few other things. So with the stop sign example, I'm not sure that it's clear whether or not, for instance, one act could trigger 3 fails, right? So something like running a stop sign, that would, I think, at least cover 2, right? That would be the substantial safety risk, and that's going to be some sort of supervision violation, right? That you sped and you ran the stop sign. So that's at least 2 things that you're failing because you did one thing wrong. And potentially, on the circumstances, maybe that's even a delinquent act, so then you're maybe failing 3 things off of one situation. So because of the way this is written, where it is like these 3 auto fails, there, I think, become a lot of concerns about youth failing for things that we wouldn't think they should. If this was written the way the old version was, I think some of those concerns would be somewhat mitigated, but this is really written in such a way that actually 14-year-olds are more likely, right, to end up violating and ending up in that adult prison situation than a 17-year-old, simply because a 14-year-old has 5 years of life to live, right? It is very difficult for a 14-year-old to, never, ever, ever do something that slightly breaks the rules, right? On like supervision, having a vape pen, that's a violation of supervision. Sometimes you might have supervision conditions around what time of day you need to charge your ankle monitor. Okay, so you violate that, there you go. So a 14-year-old has much more time to accrue super minor little things that would then trigger them to go into the adult system versus a 17-year-old, which they really need to just be kind of keeping it together for however long till the hearing. So maybe 18 months, maybe as little as 8 months, depending on how old exactly within that 17-year they are. Lot of issues with the way that those factors are written. Just one other thing on the factors is that currently, if you graduate high school and you did everything right, and then you go on to TCAT and you're not successful at TCAT, that's a fail. Even though you graduated high school, you go on to TCAT, you don't do well for whatever reason. Maybe school's not for you. Maybe you're having personal issues. Maybe you get pregnant, you have a baby, you got to drop out. That's considered a fail, even though you graduated high school. I don't think that's the intent of the bill, but that's the way it's written currently.
Okay, thank you. I will tell you that I do believe that we do need to do something about our minors who are continuing to test the justice system. So I'm not against, the ideal of making sure that they are ready for society. But I am against the ideal of pretty much the ideal of lock them up and throw away the key. And all that I'm hearing, it pretty much says that this is what this is about. So I think we do need to do some more work on the bill before we put it out there, because I'm not for the lock them up, throw away the key piece, but I am for doing something to ensure that those who are not ready for society do not come out. So thank you, Mr. Chairman.
Yes, indeed. And thank you, folks, for being here and testifying. Leader Lamberth.
Just briefly. One, Melanie, good to see you today.
Good to
We've
see
known
you,
each other
Leader.
almost 20 years.
Thank you.
Just to be clear here, and this is just to Ms. Bean, please. With all due respect, I'm looking for a brief answer. So we're talking about unruly and delinquent folks. Nobody's going to prison here, correct?
And I disagree.
How so?
Because.
Juvenile court doesn't have jurisdiction to send somebody to TDOC.
Well,
TDOC wouldn't even accept them
Well,
if they
then why
did.
do we have excuse me, I'm sorry, am I allowed to respond?
Absolutely,
Okay,
yeah.
sometimes in other committees, I have to ask the
Oh,
chairman to
No,
respond first.
you carry on the conversation. That's
Thank you.
fine.
I absolutely, I disagree, Leader. And the reason I disagree is because we have hardwired facilities for juvenile offenders. We have one we have Wilder in West Tennessee. I think we have a contract facility in East Tennessee. I know that they shut down Taft about 10 years ago. Just because you call it delinquency doesn't mean that there's not incarceration that is involved. And which I think is different. And second of all, this bill is in specifically adding a 3 to 4 year sentence at age 19, not necessarily with a hearing, and because the bill doesn't specifically identify, because we're going by 40-35-303 at that point, probation isn't necessarily an issue. So it is incarceration. I believe the way the bill is drafted is by incarceration. Go ahead. I know. You're dying to try to put me in
I
my
know.
place.
No, I'm not at all. And you know better than that. We've known each other forever.
We have,
But
and I appreciate it.
my question was, the testimony earlier seemed to indicate that folks would go to prison without a jury trial. We are talking about detention. We are talking about youth facilities. But a TDOC sentence is not possible from this blended sentencing option, correct?
I disagree, because at age 19, you are giving them a TDOC sentence. They are transferred from DCS to TDOC. That is the way the bill is drafted. They are transferred from DCS to TDOC, and there are specific provisions built within this bill about how they have to be housed by TDOC, but it's still TDOC. You can call it whatever you want. It's still TDOC.
Well, you and I will simply disagree on that, and we have
Okay.
over the years. And by the way, full disclosure in this committee, the two of us have gone back and forth on dozens and maybe hundreds of cases. Have all the respect in the world for Ms. Bean. She's a phenomenal lawyer.
Thank you.
We just disagree on this one. And to the previous comment, I am been against basically every single one of these blended sentencing bills because I would prefer to transfer them, which is the alternative. These folks should not be in juvenile court. They should be in jail. They should be in prison. They should be adjudicated and convicted of the felonies that they have committed. But at the same time, I just wanted to ask that question. You and I would disagree on it, but I don't logistically know of any possible way where a judgment has come down from a juvenile court, which is not a court of record, which is a sessions court, that TDOC would even accept. I get we're talking semantics somewhat, but from the testimony earlier, it seemed like there was an indication that these folks would serve a TDOC sentence. And I can understand now the distinction on it. And I appreciate that, obviously. So thank you.
And the same, I do respect you as well, leader. And we have worked together over the years, and I do appreciate that and hope we can continue to do so.
Absolutely. Thank you.
Representative Towns.
As it relates to the two separate sentences, 3-4 years after the initial sentence, would that be considered as double jeopardy in any kind of way?
The way the way the bill is drafted, it's basically a resentencing. And again, this may get back to some of the semantics that, that one person could look at it a different way, but it's a resentencing of the same offense. And so, that's an interesting concept, Representative Towns, that, would the individual be, would that cause the secondary sentence to be subject to some sort of double jeopardy? That could be something that could be raised. And you also have to consider, if you look at some of those factors under G5, picking up a new charge and being sentenced on a new charge is actually a basis by which to give that second sentence. So in some respects, are you being sentenced twice for one particular crime? So I think those are additional issues, again, that just need to be shored up within a blended sentencing bill. This blended sentencing bill is different than the other 19 states that I understand have blended sentencing. Most of the other blended sentencing bills do include some portion of a jury trial, or does require a jury trial. And I think you would really have to sort of build that in on the front end in order to really fix that underlying issue. Does that answer your question?
It does, but with that, a classic double jeopardy is what then? I mean, I always thought that
Being tried twice for the same crime.
that's what I've always been taught.
That's the simplest form to say it, being tried
Okay.
twice for the same crime.
That is
In this
fine.
situation, you're being punished twice for one crime
Right. And
without a
just-
trial. Thank you.
Yes, without a trial. And just to clarify the nature of that Department of Corrections issue, it says on page 4 of the amendment, if the court imposes an additional disposition beyond a serious youthful offender's 19th birthday, then the court shall enter in an order on or before the offender's 19th birthday, committing the offender to the supervision of the Department of Correction to serve the additional sentence imposed by the juvenile court.
Mr. Chairman, thank you. Thank you, ladies. Thank you.
All right. Thank you so much for being here. I appreciate your testimony. We're going to go back in session. You have questions? Yes. Well, then I've got to go back out of session.
I can feel the love.
Can you expedite this?
Yes, sir. I'll really try.
Thank you.
Seems like this bill has been expedited. So the amended, what is that?
That's all right. Go ahead. Proceed.
Gallery there. The bottom line is that you consider this bill as amended to be unconstitutional or just suspect?
I believe it has unconstitutional issues within it because it does not allow for a jury trial, and we are incarcerating an adult at age 19 without a jury trial. Those are the fundamental principles of our justice system, federal and state. And I believe that it would take a constitutional amendment in order to modify that.
All right. And you, ma'am?
I think that it is likely unconstitutional. I mean, there's no case law specifically on point on this issue. I think because of the fact that the 19 other states that have blended sentencing have a right to the jury trial at some point in the process, so that issue hasn't been raised as a challenge to the blended sentencing scheme. So I think there are some concerns, yes.
All right. Thank you, ma'am. Thank you, Chairman.
Indeed. We're going back into session now. Vice Chairman Gillespie.
Thank you so much, Mr. Chairman and sponsor, and to Chairman White, who's not here, and the speaker. I just really appreciate this legislation. This is something that my community and my district's been screaming for, and allowing us to have this third option is, I think, paramount to our public safety issues and concerns that are happening in my neighborhood and with the people that I represent. So on behalf of all of them, thank you.
Leader Lambert.
Move previous question.
Previous question been called. Is there objection? There's objection. We're going to vote. All those in favor of previous question say aye. Aye. All opposed, no. Ayes have it. Previous questions called. We're voting on House Bill 0430. All those in favor say aye.
Aye.
All opposed, no. Ayes have it. Moves on to Finance, Ways and Means. Which brings us now to item number 4, which is House Bill 1817. I hear a second. Did I hear a motion? All right, Chairman Lady Littleton, you are recognized.
Thank you, Mr. Chairman. I'm going to try and I want to roll this for a week because it has a hefty fiscal note, which tells me what a problem it is, but I would like to get something out of it. So I'd like to roll this 1 week, please.
All right, 1 week.
Yes, please.
All right, House Bill 1817, roll 1 week. Moves us to item number 5, which is House Bill 2163. You have a motion and a second. You are recognized.
Thank you, Mr. Chairman. This bill says, with regard to the sexual exploitation of children, the present law defines material as any computer image or computer-generated image, whether made or produced by electronic, mechanical, or other means. The bill amends the provisions to clarify that computer-generated image includes an image created, adapted, or modified by artificial intelligence.
Any questions for the sponsor? Seeing none, we're voting on House Bill 2163. All those in favor say aye. All opposed, no. Ayes have it. Moves on to calendar and rules.
Thank you, Mr. Chairman and committee.
You're very welcome. Moves us to item number 6, House Bill 2126.
Second.
Who's got this one? Well, let Tyler run it there if he can't find grills.
Mr. Chairman, I make a motion, you roll it to the hill.
Well, we'll roll it to the heel. All right. Brings us to item number 7, House Bill 2031 by Representative Barrett.
Motion.
Have a motion and a second. Sir, you're recognized.
Thank you, Mr. Chairman, members of the committee. House Bill 2031 seeks to increase the penalty laid out in TCA 3917-307 for intentionally obstructing a highway, street, or other place used for passage of vehicles or conveyances from a Class A misdemeanor to a Class D felony. It also adds a private right of action for anyone damaged by that act. And with that, I stand ready for questions.
Okay, thank you, sponsor. I think we have somebody to testify on this bill, Macy Fluharty. Is that correct? Thank you. Please make sure the light's on your microphone, and please tell us your name for the record. You have 3 minutes, ma'am.
Thank you. My name is Macy Fluharty. I'm a Davidson County resident. When a government consistently ignores the outcries of their constituents, people are allowed their right to protest. The people have a right to protest in public spaces, including streets. This bill hinders that constitutional right. Should a protest become so large that it blocks traffic, misdemeanor charges can already be filed. In practice, this bill would change those charges to a felony, which is ridiculous. Felony charges include things like kidnapping, grand theft, murder, whereas misdemeanors are used for smaller crimes such as vandalism, disorderly conduct, blocking traffic. A misdemeanor holds a shorter sentence. This bill could subject peaceful protesters to years in jail just for exercising their First Amendment rights. This bill is fundamentally un-American. The goal of mass protest is to bring attention to a cause not only to those in charge, but to the world, because those in charge may be unreasonably non-compliant. We march when change is necessary for a fair and just world, but that demand for change is ignored. It is not the intention of the people to have a run-in with police or to block traffic, though officers could easily claim otherwise. We may know these are risks, but they are not a goal and oftentimes are avoided as much as possible as we the people can while still participating in our right to protest. If a traffic jam is unavoidable, drivers, including emergency vehicles that should be aware of their city's happenings, can find an alternate route to their destinations. In subcommittee, it was confirmed that this bill can be used to deter people from protesting in the streets. This is not how you avoid such a protest. The way a government can avoid such a disruption is to work with their communities to bring safety and equality that we demand and deserve. Instead of working with your constituents, this body is bringing on legislation to further criminalize Americans for utilizing their rights given to us through the birth of our country. This bill is ridiculous, it is un-American, and it is shameful that this is what our lawmakers are choosing, to lock away their concerned constituents instead of serve us as you swore to do. Please vote no. This bill will do nothing but show the world what Tennessee thinks of our rights, which seems to be very little. Thank you.
Okay, any questions for Ms. Fluharty? Representative Hardaway.
Thank you, Chairman. Thank you for being here, ma'am. Excuse me. Now, I'm assuming at some point you may have participated in a protest.
Yes, I have.
And the very nature of a protest is to be disruptive to a government that you want to gain redress from.
Yes.
And in the history of America, we found that protests can vary in terms of the type of protests, the intensity of the protests, et cetera. But what's usually consistent is that these are Americans who are not happy with the way that the government is operating, and they're seeking to change government. And that's a constitutional right.
Mm-hmm.
Okay. That's all I have, Mr. Chairman.
Any
Except
other comments or
I can't
questions?
support this bill.
Representative Johnson.
Have you ever been in a protest that blocked traffic? Was it intentionally? Was it unintentionally?
I have been in a protest that blocked part of a roadway. It did not completely block the roadway. It was not intentional to my knowing. I was not one of the organizers of this protest, which is another thing that people can get caught up in, is that they don't have control of how a protest ends up.
Mm-hmm.
But yes, I have been part of a protest that has blocked part of a roadway, not completely, and that protest did end up in violence against constituents.
Okay. Oh, I was just curious because I've been part of a protest where they did go across the road, and I wasn't comfortable with that, so I stayed on the curb. But also, I didn't know that they had permission from the officers to block the road for 7 minutes. I was not aware of that, but it turns out that they did. So a lot of times, people in the protest aren't aware of what permissions are and all that.
Correct.
Representative Towns.
Mr. Chairman, thank you. Two things. I might have said it before. Salam. First thing is, a lot of our young people, really young, are the ones that are participating. 17, 18, 20, 22 years old. And what we got to have is a spirit of them being able to be redeemed, as I've shared before, and not really wreck their lives forever with a felony. Felonies are a real serious scarlet letter that people actually deny you jobs, access to certain benefits and other things. That makes me pause. Okay, that makes me really pause. And Mr. Chairman, the other thing that concerned me is that as I think about what we are deliberating over, I was thinking about, what would have happened to our people years ago in the women's suffragist movement. How far would that have gone? Would they have been classified as? Because that was not an easy movement, okay? And history allows us to go through some other movements to see just how far do we go in classifying people to that extreme. Now, obviously, when people out of order conduct, we have to do certain things to, to keep the order, but going to the extreme, it just giving me pause. And I don't know how many movements you've been in, how many marches you've been in, or whatever protests you've been in, but it can be, democracy has to have the ability to be able to absorb the heartache and the messiness and the the uncertainty and the fussing and cussing in order that it continues to grow. Democracy has to be a living, breathing organism that has the ability to change through the process of. Now, what also concerns me is you look around the world, people still watch our country and they are wanting to emulate and have some of the things we have. But in many of those areas where there's protests, or if there is not protest, there's always going to be a groundswell. A groundswell many times erupts into really violence. And that's what we don't want. You want to hear from the people. Don't want everybody to go too far. You don't want the law to go too far. You don't want the people to go too far. But you got to hear from the people. It's just how it is. Whether it's democracy or not, you need to hear, because it's going to come out one way or the other, like a pressure cooker. You keep it down, and eventually just, it blows. Mr. Chairman, thank you.
Chairman Doggett.
Thank you, Mr. Chairman, and thank you for being with us today. A lot of the conversation that folks are asking about is dealing around, sounds like planned protest where police knew that there were going to be people in a certain area that'd be crossing a street or in a street, and there was police presence there to make sure and at least ensure the safety of those that were there for both sides. But are you advocating on behalf that people just randomly protest and storm highways and interstate systems and block traffic and shut it down and prevent people from being able to move freely? Do I understand, is that what you're advocating on behalf of?
No, I'm advocating on behalf of American citizens being able to exercise their constitutional right to protest. And if that protest becomes large, then we should be able to redirect the protest rather than charge felony charges against people. Police can be trained to de-escalate situations. They can be trained to redirect people away from traffic, and that's what we should be doing. We should not be trumping up charges to give people felonies.
But what if there's a large group of people that shut down like a major interstate right outside the Capitol here, and they shut that down in the middle of rush hour with a large crowd and don't allow vehicles to pass? Is that what you would say is acceptable? They're exercising their constitutional rights in that manner?
I would say that police would have the opportunity to redirect those people in a peaceable manner rather than charge them with felonies and oftentimes resort to police violence.
In the event that police are not able to get there because it's such a large crowd, and then you've got people that are trying to commute on the roadway and they end up being attacked, their vehicles are damaged or they're drug out of their vehicles and attacked, would that point?
Sounds like a separate charge to me.
No more questions.
Chairman Russell.
Thank you, Mr. Chairman. And my question's for legal. Is there anything in this bill that prohibits somebody from getting a permit and marching down the street?
Michelle Fogarty, Office of Legal Services. In order to violate the statute, you have to, without legal privilege, intentionally, knowingly, or recklessly obstruct the highway, street, sidewalk. So it's without legal privilege.
So somebody can go through the legal channels and still do a march down the street.
This statute does not criminalize people who have a permit, who are acting within the bounds of their permit.
Very good. It sounds to me like if they go through the legal steps, they can march down any street they want to. Thank you.
Representative Fritz.
Thank you, Mr. Chairman. And thank you for testifying, because this is part of what makes government work. But when I read our Constitution, the Constitution in our constitutional republic is a contract between the citizens and the government. And so those guarantees to peaceably or peacefully, depending on which document you're reading, assemble, I see it as to apply for redress with the government. If we start to stop all commerce, or if we decide to invade a private property as a way to bring awareness, I think that generally falls into a trespassing thing with the private property. So we're not, my question with all that is, you're not advocating an ability to go march on a private property to raise awareness to an issue, are you, ma'am?
Correct, I am not.
All right, thank you, Mr. Chairman.
Representative Johnson.
I guess that I was thinking in my head, just trying to think of large numbers, and nobody expected. There's sometimes where large numbers show up that you don't expect. So when you're moving and crossing the street, I think of the Women's March, and I think of how massive that became and how streets were stopped just because of sheer numbers. There couldn't have been anything more peaceful than that protest. But just by sheer numbers, as movement happened and all that, roads were blocked and places were blocked.
Okay. We're going to go back into session. We're back in session. Vice Chair Gillespie.
Thank you, Mr. Chairman. To the sponsor, I just wanted to thank you for bringing this. I think everyone in this country has the right to peacefully protest. Everyone in this country has the right to apply from a permit from whether it's the city of Memphis or the Department of Commerce. I think there are methods already in place to be able to allow those protests to happen, whatever the reasoning or rationale for the protest are. All we're simply trying to do with this bill is to say that the 10,000 people that are being stopped also have rights. And I think this is a very fair way to go about doing that. And I'm, full support of it. And I just wanted to thank you. No questions. I just want to say thank you.
Leader Lambert.
Thank you, Mr. Chairman. Thank you for bringing the bill. I echo my colleagues' comments. We have a right to peaceful protest. What you don't have a right to do is keep one of my constituents or yours from being able to get to work on time, from being able to get their kid to school on time, from being able to get to the doctor or the emergency room. Don't block the street. It's not safe for those that are protesting, and it is not fair to other citizens who paid for the very roads that these protests happen on from time to time. And to the question earlier about blocking an interstate, I don't want to see someone hurt out there because a large truck can't stop as fast as a small vehicle. And yet you have folks that from time to time, for whatever reason, decide that it's a good idea to go play in traffic in the interstate. That is horrible. If you want to protest, and my other colleagues comment, in most circumstances, I think the First Amendment is my permit to protest. As long as I'm peaceful, but I do not have a right, and you do not have a right, and no one else has a right to stop my constituents from being able to get to work. And that's what we've seen all over the country from time to time, is that folks will lay down in traffic, and you have people getting out of cars begging them to move, saying, look, if I don't get to work on time, I'm going to get fired. And yet they don't care. because laying in the road somehow or another makes them think that that's going to change somebody's mind. It doesn't. It's just a jerk thing to do to some other citizen who's just trying to get to work or school or whatever else. And so protest anywhere else just about you want to, permit or no permit, as long as it's peaceful, but don't block your fellow citizens from being able to go about their lives as well. It also has the counter effect, because I can guarantee you, if I'm headed down here to serve the people of my district and there is a road that is blocked down by a protest, whatever they're protesting, I'm probably going to vote the opposite way, because that in itself proves to me that you don't want to come down here and let your voice be heard. It's just about you and showing out. Just my opinion.
Chairman Farmer.
Thank you, Mr. Chair. I called the previous question.
Previous question been called. We are voting on House Bill 2031. All those in favor say aye. All opposed, no. Ayes have it. Moves on to Finance. That brings us to item number 8, House Bill 2159, also by Representative Barrett. Have a motion? There's a second. Sir, you're recognized.
Thank you, Mr. Chairman. House Bill 2159 adds a section to TCA 3917-902 to create a civil right of action for a violation of that statute.
All right, any questions for the sponsor? Representative Hardaway.
Thank you, Chairman. Violation of what statute, sir? Would you describe the nature of the statute?
Yes, sir. TCA 3917-902 is the criminal obscenity statute, sir.
And how will your bill impact it?
Free to go back and forth, Mr. Chairman.
Yes, sir. Please
Thank you.
do.
Representative Hardaway, as we discussed in subcommittee, this bill would simply add a paragraph to that statute. It does not change any definitions or anything regarding the criminal portion of the statute. It simply allows private citizens the ability to sue for civil damages that may be incurred due to a violation of the statute.
Thank you, sir.
Any other question for the sponsor? Representative Johnson.
Just to clarify, that's the legal definition of obscenity in that code, correct?
Yes, ma'am.
Thank you.
Okay. Representative Towns, are you speaking of obscenity and pointing to the man on your right? That's a bad thing right there. All right. No more questions. We're voting on House Bill 2159. All those in favor say aye. All opposed, no. Ayes have it. Sir, it moves to calendar and rules. Puts us back to item number 6. There's a motion and a second. We're on House Bill 2126 by Chairman Grills. Sir, you're recognized.
Thank you, Mr. Chairman. And I do believe that there is an amendment, though, that's a friendly amendment.
That's what I'm showing is what number you have.
I do not have it, but Chairman Doggett is the one who filed the amendment.
Well, I'll give you Chairman Doggett's number. It's 014134. How's that?
Don't call after 9, please.
We have a motion, a second on the amendment. All those in favor say aye. All opposed, no. Ayes have it. The amendment goes on to bill. Go ahead, sir.
My legislation would allow the juvenile court judge the option of moving any juvenile 15 years old and up to be transferred to adult court for the crimes of organized retail theft or theft of a firearm and attempting to commit these crimes. And that's what my bill does. Chairman Doggett, his amendment, I do believe, has something to do with the incarceration and the where they would put the trespassers or the criminals that committed these acts.
Chairman Doggett.
I've got it. Yes, sir. Thank you, Mr. Chairman. So just to address the concerns of having the juvenile come into an adult facility like your county jail, what they're doing here is the sheriff has to say that they are able to comply with the sight and sound requirements and that they're not, by doing this, are not going to be placed into overcrowding. And if for some reason they cannot comply with this, with being able to house the juvenile, then the juvenile will remain in juvenile detention.
Representative Johnson.
Okay, thank you. That might have halfway answered my question. So my question is, what about focusing on the rehabilitation that this young person is going to need? Are they going to get that in that adult facility?
Thank you, Mr. Chairman. And what will happen when this juvenile commits this delinquent act, the DA will petition the court. They will go before a juvenile court judge, and they will either be granted the ability to transfer to an adult court, or they will keep them in the juvenile system. So that's how that will take place. And the juvenile judge will have the ability to render what they feel is best at that time.
So if they do require some type of rehabilitation, it will be provided.
But that will be worked out between the DA and the judge.
Okay. And do we typically find that more intense punishment for youth offenders deters them from future crime?
I remember growing up, whenever my dad put a stiffer punishment on me, it seemed to work better. And I think that our country has moved away from that, and we would be better off if we had more daddies laying the law down at home.
Well,
and putting their foot down and saying, Junior, you're not doing this, and if you do this, this is what's going to happen to you. And because we don't have daddies doing that, we're seeing a rise in crimes, and we're seeing less respect for other individuals' property and places and things of that nature.
And I understand that's anecdotal experience. What I'm talking about is research and data, because it seems to be potentially counter to that. But my biggest concern for this is that, are these juveniles going to get the help that they need, rather than ensuring that they become hardened criminals because they are in an adult facility? So thank you for your answers.
What I fear that what's happened, at least back in my part of the world, is that juveniles have been preyed upon by gangs because they have gone out and stolen weapons, and they're committing crimes to facilitate gangs. And because of their ability to get slapped on the wrist and turn loose, they are creating criminals at a younger age. And now if we can stop that, we will prevent those young individuals from becoming hardened criminals, as you said.
And I firmly believe that we can stop that by making sure that they have the experiences they need to become different when they are released later. And typically what research will show you is that there are many different ways we can get that. And it's usually not from some of the things that you indicated, according to data and research. But I respect your opinion, and I just will disagree, but I do appreciate that there is consideration to these young people going to an adult facility.
And I feel like that's being recognized in the fact that the DA will have the ability to petition the court, and the judge will then have the final say whether to transfer this individual. So it's not just every kid that commits one of these delinquent acts is thrown into the adult system. They have discretion.
Representative Glenn.
Because every kid's not in a gang.
That's correct.
Okay. All right. Any other question for the sponsor? Representative Hardaway.
Thank you, Chairman, and good afternoon to the Ball Caucus Chair.
Thank you. Good to see you too.
Good to see you, sir. Now, how will this bill of yours, how will it match up against the blended sentencing bill?
Good. I was in and out with that bill. I'm not particular. I don't really know how the particulars are working with that. I know we worked with the Chairman Farmer probably can answer that question since he presented the blended sentencing bill. So maybe he's the one that we need to direct that question to.
Chairman?
Yeah, I think, Mr. Chair, and Representative Hardaway, this would not have any impact. The blended sentencing bill only deals with A and B felonies. This is a low-level felony, I believe an E. So this is not correlated or tied to the bill that we discussed earlier.
All right, thank you very much.
All right. We are voting on House Bill 2126. All those in favor say aye. All opposed, no. Ayes have it. Move to calendar and rules. Before we have an adjournment.
Thank you.
Mr. Tyler, we would like to have your wisdom and words of wisdom for the day.
Good afternoon, everyone. It's been a splendid day. Today's words of wisdom are brought to you by world champion Rocky Balboa. Every champion was once a contender who refused to give up. Y'all have a great night.
Motion to adjourn. We are adjourned.